Hello everyone, my name is Elena Chang and I will present the scenario 1. The first issue is whether Brilliant Bank Berhad is liable for honoring a check containing a false drawer, signatures and debiting Carol Ahmed trading account without authority. In a banker-customer relationship, the bank can only withdraw money based on the customer's valid instruction or mandate. A check is an instruction from the customer to the bank to make payment. If the bank acts outside this mandate, it may be in breach of its contractual duty and generally liable for any loss. This principle was stated in Thai Hing Cotton Mill Ltd versus Liu Chong Hing Bank, where the court holds that a bank must strictly follow its customer mandate and is not entitled to honor check with false signatures. Any loss must generally be borne by the bank. In addition, Section 23 and 24 of the Bill of Exchange Act 1949 provide that a person is not liable on a bill without a valid signature and a false signature is completely ineffective. This means a false check has no legal effect against the account holder. This was supported in United Asian Bank Berhad versus Thai Sun Heng Construction, where the court holds that a bank cannot debit a customer account based on a false check. Similarly, in Syarikat Islamiyah versus Bank Bumiputera Malaysia Berhad, it was confirmed that once forgery is proven, the bank is liable. However, under Section 73 of the Bill of Exchange Act 1949, a customer may be preempted for denying a check if their own negligence would contributed to the forgery. This was explained in London Jock Stock Bank versus Macmillan. The court held that borrower must take reasonable care. In this case, the check for 50,000 ringgit was paid by Brilliant Bank, but the customer confirmed that signature was false. There is no evidence of negligence by Carol Ahmed Trading. Therefore, the payment was unauthorized, and Brilliant Bank acted outside the customer mandate. In conclusion, Brilliant Bank Berhad is liable for honoring the false checks and debiting Carol Ahmed Trading's account without authority. Under Section 24 of the Bills of Exchange Act 1949, a false signature is invalid and the bank must bear the loss. Next is Issue 2, whether Carol Ahmed Trading is entitled to recover the 50,000 ringgit from Penny after the proceeds of the false check was credited into her account. Under Section 24 of the Bill of Exchange Act 1949, a false signature is completely invalid and has no legal effect. This means no right can be transferred through a false instrument, and any payment made based on it is considered unauthorized. In situations like this, the law allows the rightful owner to recover money that has been wrongly received by another party. This is supported by the principle in Barnes versus AD. A person who receives property in breach of trust with knowledge of the wrongdoing may be held liable as a constructive trustee. Similarly, in Likim Koma versus Kapna Ltd, the court confirmed that money received without legal justification can be recovered under the principle of unjust enrichment. In addition, Section 73 of the Contracts Act 1950 provides that a person who receives money by mistake must repay it into the rightful owner. In this case, the 50,000 ringgit check drawn from Carol Ahmed Trading's account was false and later credited into Penny's personal account. Since Carol Ahmed Trading never issued or authorized the check, the payments were clear and authorized. Penny has no legal entitlement to retain the money because the funds originated from a false instrument. Even though the money has already been credited into her account, the law allows Carol Ahmed Trading to track and recover the funds. In conclusion, Carol Ahmed Trading is entitled to recover the 50,000 ringgit from Penny because the payment was made based on the false check, which is void under Section 24 of the Bills of Exchange Act 1949. As Penny has no lawful basis to keep the money, she is required to return it. Next is Issue 3. whether Wangwa Bank Berhad as the collecting bank is liable for collecting the full checks and crediting the proceeds into Penny's account, or whether it is protected under the Bill of Exchange Act 1949. A collecting banker acts as an agent for its customer when collecting check and must exercise reasonable care in handling check transactions. Section 82 of the Bills of Exchange Act 1949 provides protection to a collecting bankers when collecting a closed check in good faith and proper banking practice. If these conditions are met, the bank is not liable for any defect in the customer title. However, if the bank is negligent and fails to take reasonable care, it may lose this protection and become liable. This is supported in CIMB Bank Berhad versus Panaron Control Sendirian Berhad, where the court holds that bank must exercise reasonable care and skill when handling check, and failure to do so may result in liability. Further support is seen in Mafani and Court Ltd versus Midland Bank Ltd, where the court confirmed that statutory protection only applies if the banks act in good faith and without negligence. According to Section 85 of the Bill of Exchange Act 1949, it provides statutory protection to a collecting banker who collects a closed check for a customer in good faith and without negligence. Where these requirements are satisfied, the collecting banker will not liable for conventions. In Mafani and Courts Ltd versus Midland Bank Ltd, the court holds that a collecting banker may rely on statutory protections only if it acts in good faith and without negligence. Whether the bank is negligent depends on whether it exercises reasonable care and complies with ordinary banking practice when collecting the checks. In this case, the 50,000 ringgit check from Carol Amen Trading was made payable to Chang and later credited into Penny's personal account at Wangwa Bank Berhad. This is a large and unusual transaction. Despite this, the bank failed to conduct proper investigation or verification before crediting the funds. Therefore, the bank is deemed negligent and loses statutory protections. In conclusion, Wangwa Bank Berhad is liable as the collecting bank for crediting the proceeds of the fraud check. The bank is not protected under the Bill of Exchange Act 1949 due to negligence and is responsible for the loss suffered by Carol Amen Trading.
Madam Ida, I am Regina Melanie and I will discuss scenario 2. The first issue is whether Mamat obtained a valid title to check number 223790 after altering the pay's name without Carol Amen's authority. Under Section 76 of the Bills of Exchange Act 1949, a cross check provides greater security, while Section 78 states that any unauthorized alteration to a check crossing is unlawful. Further, Section 64 subsection 1 provides that a materially altered check is void if the alteration is made without consent, and Section 64 subsection 2 states that changing the pay's name amount to a material alteration. This was confirmed in Arab Bank Limited versus Rose 1952. In addition, Section 81 provides that a person receiving a check cross not negotiable cannot obtain a better title than the transferor, as illustrated in Wilson and Mason versus Pickering 1946. In this case, Mamat stole check number 223790 and changed the pay's name from Yamis Berhad to his own without authorization. This constitutes a material alteration under Section 64, subsection 2, making the check void under Section 64, subsection 1. Furthermore, because the check was crossed not negotiable, Mamat could not acquire a better title than the one he possessed. Since he obtained the check through theft and fraud, his title was defective from the outset. Therefore, Mamat did not obtain a valid title to check number 223790. The check was rendered void by the unauthorized alteration, and the not negotiable crossing prevent him from acquiring transferring a better title. The second issue is whether Nova Bank Berhad is liable for collecting check number 223790 on behalf of Anas despite the check having been altered and stolen. Under Section 64 subsection 1 and 64 subsection 2 of the Bills of Exchange Act 1949, a check that has been materially altered without consent is void, and changing the payer's name constitutes a material alteration. However, Section 82 protects a collecting banker who acts in good faith and without negligence. This principle was established in Marvani & Co. Limited versus Midland Bank Limited 1968 and applied in London Joint Stock Bank versus Macmillan and other 1918 and also in United Asian Bank Berhad versus Thai Sun Heng Construction Sdn Berhad 1993. In this case, Mamat altered the payer's name from Yami Sdn Berhad to his own using chemical means, making the alteration invisible. He then transferred the check to Anas, who deposited it with Nova Bank. There is no evidence that Nova Bank was aware of the fraud or act negligence. Since the alteration was not apparent and the bank followed normal procedure, Nova Bank acted in good faith and without negligence. Therefore, although the check was void under Section 64 subsection 1 and 64 subsection 2, the Nova Bank Berhad is protected under Section 82, and the Nova Bank Berhad is not liable for collecting the check number 223790. So that's all from me. Thank you.
My name is Chong. For issue 3, the question is whether Anas as the transferee acquires a better title to the not negotiable cross-check than the transferor. Under Section 29 Roman 1 of the Bills of Exchange Act 1949, a holder in due course is a person who receives a check in good faith for value and without knowledge of any defect in title. Anas accepts check number 223790 as payment for a television worth 10,000 and was unaware of Mamat's fraudulent conduct. However, Section 81 of Bills of Exchange Act 1949 provides that a person who receives a check cross not negotiable cannot obtain a better title than the transferor. This principle was confirmed in the case of Wilson and Mason versus Pickering, where the court held that although a not negotiable check can be transferred, the transferee cannot acquire a better title than the transferor. In this case, Mamat obtained the check fraudulently and altered the payer's name without authority. Therefore, Mamat's title was defective. As a result, even though Anas acted honestly and in good faith, he is still affected by Mamat's defective title. Although Anas qualifies as a holder in due course under Section 29 Roman 1, his rights are limited by Section 81 of the BEA because the check is marked not negotiable, which prevents him from acquiring a better title than Mamat. In conclusion, Anas cannot obtain a better title to the check under Section 81 of the Bills of Exchange Act 1949 and cannot claim as superior right to the check proceeds. For this issue, we need to determine whether Brilliant Bank Berhad is liable for paying check No. 223791 when Carol Ameng's signature was forged. Under Section 24 of the Bills of Exchange Act 1949, a forged signature is wholly inoperative. This means the check is invalid and the bank has no authority to make payment based on that check. In the case of United Asian Bank Berhad versus Thai Sun Heng Construction Sdn Berhad, the court held that a bank may be liable for loss caused by forged checks. Similarly, in Syarikat Islamia versus Bank Bumi Putra Malaysia Berhad, the court stated that the customer only needs to prove that the signature was forged. Furthermore, in CIMB Bank Berhad versus Panaron Control Sdn Berhad, the court emphasized that banks have a duty to exercise reasonable care and skill when verifying signatures before honoring checks. In this instance, Mamat forged Carol Ameng's signature on check No. 223791. More importantly, Mr. Marco, the bank officer, noticed that the signature did not match the specimen. Despite this discrepancy, the bank still proceeded to honor the check. Section 73A BEA may protect a bank if the customer contributes to the forgery through negligence. However, there is no evidence that Carol Ameng was negligent or facilitated the forgery in any way. Therefore, Section 73A does not apply. In conclusion, Brilliant Bank Berhad is liable for paying the forged check because the signature was invalid under Section 24 of BEA. The bank failed to exercise reasonable care when verifying the signature and must recredit Carol Ameng's account for the amount wrongly debited. That's all from us. Thank you.